Good afternoon. Welcome to another edition of Legal Access. We get together each and every Thursday at this time to give you access to different aspects of the law. Today we're going to be talking about workers' compensation. If you've been hurt at work or you have a family member who has, you want to know what you should do and what you shouldn't do, today is the day to get those answers. Phone number is on your screen, 843-848-8080. Give us a call and we'll get answers to your questions here today. On the panel to answer those questions for you, first of all, from the McGuire Law Firm is Ian McGuire.
Good to see Dave.
Also from McGuire Law Firm is Mike Smith.
Hello, Dave.
And at the end of the table from the O'Neill Law Firm is Rick O'Neill.
Good afternoon.
Yeah, it's great to have Rick back with us. Rick, you're here so much, I shouldn't even, you're not really a guest at this point, but Rick practices obviously in the area of workers' comp, but also does personal injury, which you've been on the show a lot for, and including car wrecks and premises liability. But as we've said before on the show, Rick's background initially was in law enforcement, and so he still handles criminal cases, and his office does as well. But of course, today's topic is workers' comp. If you have any questions on any of those topics I just mentioned, feel free to call. But you know, we are going to concentrate today on workers' compensation, which the three of us all handle. You can give us a call, Dave, right?
Absolutely.
843-848-8080. That's 843-848-8080. If you have any questions, whether you've been injured, know someone that was injured, or own a business and have questions about that, we're here to help you and answer your questions.
And again, from both sides, if you are an employer or a manager and you need to know what you should do if an employee comes to you and they're hurt, that's a good question. Let's go ahead and start off with that. If you are a manager or an employer or an owner and somebody comes to you and they've hurt themselves on the job, what's your responsibility?
Rick?
Well, you need to follow your insurance company's guidelines. They usually give you a packet with, a fill in the blank form to fill out, send it into the insurance company to get the claim started. The insurance company will then notify the Workers' Compensation Commission that there has been an injury, and then the insurance company usually takes it from there and lines up treatment. Whether, if it's an emergency, definitely go to an urgent care or hospital, whatever is appropriate. But after that, the insurance company pretty much directs the care. They choose the doctor, the facility, and they have to pre-approve any testing and so on.
All right, how about from the other side of the equation? If you're an employee and you get hurt, what's the first thing you need to do?
Probably notify your employer of the accident and get a written report if you can filed with your employer.
How severe does it need to be for you to go ahead and get in touch with somebody?
Right away, for any of them.
Yeah, it's safer to just do that. Just get in touch. If it doesn't end up being anything significant, great. But the problem is if 30 days go by and it's sort of one of those annoying injuries that's sort of getting worse over time and it's never been mentioned, even though technically you have 90 days to put the company on notice, it just makes it a lot more difficult, and there's a lot more skepticism towards your incident and injury if you don't have that initial report filled out. So it just makes sense for everybody to, even if you think you're okay, but there was an incident, to have some kind of proof or a notification of the incident.
Are you expected to get a copy of that incident report back?
Technically they should give you a copy. I don't think it's all that important, but I guess, Rick, I
don't think there's a legal requirement,
Yeah.
but just take your phone, take a snapshot of what you're filling out.
Right.
Yeah.
And one of the things that I can tell you, and this is from somebody that is newer to the workers' comp field than these two guys on either side of me, is don't think you can handle this yourself. One of the things that I would advise people is go get a lawyer as quickly as you can. Don't worry about the fact that you may not think it's serious enough, but you do want to sit down and talk to somebody that knows what they're doing. There are so many different rules and regulations involved in the workers' comp, the deadlines for making reports and things like that, that I would definitely suggest contacting an attorney.
And for our viewers that live across the border in North Carolina, our systems are similar, but workers' comp is a state-by-state system. In North Carolina, there's a 30-day time limit to report it, and it has to be done in writing generally.
Yeah, it's just that, as Mike and Rick are mentioning and talking about, is the other side, the insurance company has lawyers working for them behind the scenes from the moment there's some evidence of an incident. There's no reason that you shouldn't level the playing field and speak to somebody. There's a number of good lawyers in this area, Florence, North Carolina, where they'll sit down and talk to you, and it's not going to cost you anything for the initial visit, but most of the time it does make sense to make sure that you're properly represented.
And does it matter if you're a part-time employee or a 1099 employee?
Well, 1099 is a whole different ball game, but once again, if you think you're an employee and not a contractor, then even if there's a 1099, sit down with an attorney. Just all the more important to sit down with an attorney in a case like that, because there might be a presumption that you're not an employee if there's a 1099, although we've had numerous cases where someone is considered an employee under workers' comp that the employer has them fill out a 1099, right, Rick?
Right. The 1099 schemes that some employers use as an attempt to, avoid paying the full insurance premium or paying employee matching taxes. And, not all 1099 employees are considered employees under workers' comp. But, there's a lot of pressure out there to be competitive, and that's, especially in the construction trade, we see that a lot, that people are classified as a 1099 to the employer, but workers' comp is probably going to a lot of times classify you as an employee entitled to benefits.
Yeah, and there's a 4-point test that is used to determine if someone's an employee versus subcontractor, but essentially you could take the aggregate of that test, the 4-point test, and really it's a matter of, does the employer have certain control over the employee? If so, the more likely they're going to be an employer relationship as opposed to a contractor-subcontractor relationship, right, Rick?
Right, and if I can just add something, since we're talking about initial setting up the claim, when you're going to the hospital, don't let anyone, your crew leader, the boss, come in and try to pressure you. Hey, tell them you got hurt off the job. Tell them you got hurt over the weekend, because that statement is going to follow you through the whole claim, and we see that also. That's a very common problem that we have in our claims, especially in the construction trade.
Yeah, and then subsequently you're saying, well, what do you say? I lied, and well, they told me to lie, so I did it, and that happens. But you just don't want to do that. And if you get in that situation, contact an attorney, and they'll tell you how to work through it. We are very sensitive to the fact that people have jobs, and they don't want to upset their employer by doing anything that might cause them to lose their job or lose their position. And so we understand or sensitive to that. At the same time, always tell the truth, because it comes back and will bite you. And anybody that wants you not to tell the truth is something I would be skeptical, to say the least, of what their true
What we see is weeks down, in those situations, weeks, months down the road, the employer initially, hey, we'll take care of you, we'll pay you while you're out of work, we'll pay your bills, and then when it comes time to approve MRIs, physical therapy, 6 weeks later, they're like, no, we can't do this anymore.
They realize that, ooh, this is more expensive or more time consuming than they thought it would be, and then things change. So, it goes without saying, just the truth is the truth, so make sure that the narrative is the truth.
All right, going to run to a break here real quick. When we get back, we'd love to talk to you. If you have any questions about yourself or a loved one, any family member, anybody, anything about workers' compensation, today is the day to get those questions answered. So call us, numbers on your screen, 843-848-8080. Workers' comp, that's our topic here today on Legal Access, brought to you by the McGuire Law Firm. It's Legal Access, being brought to you by the McGuire Law Firm. Workers' compensation is our topic here today. Phone numbers on your screen if you want to give us a call and ask any kind of questions as an employee or an employer. Either way is great. Give us a call and we'll get you on the air. Now, some accidents at work and some injuries are very easy to identify. The more severe they are, most likely. but there are some that are hard to see from the surface, soft tissue injuries, back injuries, and things like that. If somebody feels like they've got a strain, a pull, anything like that, how tough is it to prove that that was something that happened at work and move the case forward?
You know, if you're, again, you technically have 90 days to give notice, but if you're within a reasonable time frame, I think nobody's going to question that an incident, especially if there's an incident that is obvious. It gets a little harder if somebody's holding or moving and turning, and it's not what you would normally consider an accident, although that is an accident under workers' comp, an untoward or unplanned event. That might raise eyebrows more, but it's still, if you give notice, I would think and get to the doctor, and the doctor can causally connect the injury to the incident, I think you're going to be fine. It's a liberally construed statute when somebody is injured, so you should be fine. To answer your
What
question.
typically happens is once you make that report, Dave, to the employer, and you're complaining that you strained your back when you lifted a patient in bed, for example, if
Right.
you're a caregiver, you can't see that pull. But if you report that right away to your supervisor that you've got the pull, and then they send you to the physician that typically the employer will want to send you to, the doctor will more times than not relate the incident based on the history that the patient or the worker is giving to the doctor. So that you can't see the strained muscle, but with your bare eyes, but there is that following that track of evidence that
Right.
that is allowed.
And I mean, if you have an injury prior to the incident, but you're able to work, and then the incident aggravates or accelerates your need for care, that's covered under workers' comp. So we often have, at least initially, this attempt to defend by saying, oh, I know that for a fact that he or she had a problem before this and was having issues, last year, and that isn't necessarily going to prevent or prohibit you from having a viable, successful claim. In fact, for the most part, it's not going to hinder you at all, as long as you can demonstrate that it was aggravated or accelerated. The care is accelerated because of the incident.
What if something happens to you while you're on the job and any other circumstance might be looked at as premises liability? If you're walking down the hallway and there's a dangerous area there where either carpet or there's some tile floor and you slip, fall, or trip and fall, would that be your choice to look at it as a premises liability versus workers' comp, or do you have to file that as comp?
You can actually do both.
Yeah. Rick, you want to get into the comp part of it?
Yeah, if it's on your employer's premises, you're probably not going to have two separate claims, because your sole remedy is going to be filing the workers' comp claim with your employer. But if you're at a customer's place of business performing duties there, and you trip on their carpet, then you've got two claims. You've got the regular just injury claim at the customer's premises for unsafe premises, and then you also have the workers' comp claim. Generally, you're going to start the workers' comp claim and get that going and deal with the premises liability settlement of that at a later date. There's a timing issue that people generally need lawyers' advice to make sure they don't mess it up.
Right, most circumstances, you've got a 3-year statute of limitations on a trip and fall, slip and fall, things like that. And what we see happen a lot of times is you'll have these contractors come in and put down rugs, for example, and then they're walking through another area of the store, and the store has mopped the
Right.
floor and not put warning signs out, so that person that's delivering the rugs slips and falls on the floor. So you've got those two separate claims that you can bring.
As long as we're talking about dual claims, let's go ahead and get into other third-party stuff. If you're working and you're driving and you get into an accident and it's the other person's fault, but you're on the clock at that point in time, you have to be careful about how those claims proceed.
Very careful, yeah. That is, are constantly saying it's good to sit down with an attorney, and it might be self-serving for us to say that, but it doesn't have to be us, but sit down with an attorney, especially in those type of cases, because you're right, Dave, you could end up losing your ability to get compensated and benefits in, for instance, your workers' comp case, if you don't handle it properly and timely. So it's, on one hand, if you have to get hurt, it's not the worst way to get hurt, because you're essentially having two bites at the apple in a sense, because you're going to have your workers' comp, which provides you with certain benefits, where your third-party case, and I'll preface it by saying that the workers' comp case, when it's done, may have a lien against the
Right.
third-party case for some amount, but the third-party case is going to allow you to collect, or at least may entitle you to damages that you wouldn't get under workers' comp, such
Right.
as loss of enjoyment of life, future, future pain and suffering if you have it, present pain and past pain and suffering. All of that is stuff that you might be limited or unable to collect under workers' comp, but
Right.
you will be able to collect under the third party. So as you'd rather not get hurt at all, but if you had to get hurt, yeah, you have your workers' comp in a third party case, you probably have the best chance of completing or getting as close to proper compensation and optimize your compensation by having the two
And
cases.
as far as future medicals are concerned, that's one of the things I think, Mike, you mentioned earlier about don't try to do it yourself. That's one
Right.
of the things, if you try to do it yourself, you're going to miss out on most likely, because you don't know what your future meds are going to be.
That's exactly right. And one of the things that Ian had mentioned earlier is the benefit of having an attorney is knowing the timing of how to handle both of those cases, because once you finish the comp case, they're going to have a lien on any recovery from the third party. They could. And you do need to have an attorney that is used to dealing in the comp field to be able to negotiate that lien, or to try to handle that lien as best as they can. And again, don't try to handle it yourself. We see way too many times that is not very successful.
Getting back to car accidents here for just 1 second. I mean, if you're in the vehicle from your workplace and you get into an accident, that's kind of cut and dried. But a lot of people will say, well, I got up early to get into work, and so I'm on my way to work, so technically I'm at work, right? I mean, I know there's a coming and going law that's out there.
Right. Generally, if you're like leaving your house in your own car, headed to the office, and getting in a wreck, you're not going to be covered. However, if they told you, hey, stop and pick up copier paper, and you're doing anything to help the business, a business purpose, then you can argue that should be covered. And generally something like that would be covered. Same thing on the way home. If you're on the way but you're stopping off to make a bank deposit or deliver something to a customer, anything that you're doing, even if you're off the clock, should be covered.
Yeah, even if like you're on the phone for work and you're driving home and the boss expects you to be doing that is going to be covered. If you are driving a company vehicle that has marketing for the company, then arguably that it could be covered. So there's a lot of exceptions. Generally, as Rick said, the coming and going does not enable you to collect for workers' comp, but there are a number of exceptions. Once again, sit down with an attorney.
Just don't text and use your Bluetooth.
Yeah.
All right, we're going to run to another break here real quick. When we get back, we'll have just under 10 minutes to get you on the air. So if you have any last-minute questions about workers' compensation, don't just sit around. Get on the phone and call us right now. We'll get you on the air in about 90 seconds or so right here on Legal Access, brought to you by the McGuire Law Firm. Going into the final segment here of Legal Access, brought to you by the McGuire Law Firm. We're talking about workers' compensation, and since it is the final segment, you've got just under 6 or 7 minutes to give us a call and get on the air if you have any questions as an employee or an employer as far as workers' compensation is concerned. If you're hurt on the job and you're getting your payment from workers' compensation, how long can that payment go on?
In most cases, it's going to be a period of 10 years, a window of 10 years. If you're totally disabled, a paraplegic, quadriplegic, and brain injury cases, you may get lifetime benefits. But in this state anyway, South Carolina, there's a 10-year cap, what they call the 500-week cap. And while you're on workers' comp that time, that's also eating away into the pool of money to pay you for your permanent impairment.
Right.
Yeah, so if you were found to be permanently and totally impaired after 5 years and you got 5 years of weekly benefits, you know, that 500 weeks is now 250 weeks. And so it really, it's tough for people that are seriously injured,
Yeah,
unfortunately.
Right. If you're in one of those situations where you've been on workers' comp for a year or two, you need to also sit down with the lawyer and talk about Social Security if you've been out of work that time.
Right.
You can apply for Social Security, and then, because that's a long process in and of itself, and then if you are able to return to work, you just cancel your Social Security claim. But there is issues with timing and subrogation claims with workers' comp and Social Security. It's probably advisable to sit down and talk to someone that's handled those.
Yeah, I definitely want to echo that, because if you applied for Social Security while your workers' comp is going on, there's negative ramifications potentially to that as well. So an attorney will handle it. It's like Rick said, if you wait too long, though, you could lose your Social Security benefits. If you do it too early, it messes up your workers' comp case potentially. So absolutely, if you're in that position, you're thinking, my gosh, I might want to apply for Social Security, make sure you have an attorney that you talk to before you take those steps.
And then there's another rule in Social Security disability that you have to apply for Social Security disability. You have to have worked basically the last 5 of the 10 years
Yes.
and been paying into the system. So if you're on workers' comp for several years, you may blow that
Right.
that requirement to get Social Security disability as well.
100%. So you really do, when you're in that situation, if it's a serious injury, that's one more reason to talk
Right.
to an attorney.
And there is a sweet spot there because you have to be out of work for a full year before you can collect Social Security disability. But you have to, like you said, have to be able to pay into it for 5 out of the last 10 years. Now, we talked about soft tissue injuries. How about repetitive trauma injuries? I mean, most people think of carpal tunnel syndrome, but what if you're lifting heavy boxes on a repetitive basis and all of a sudden you throw your back out or whatever the case may be? How hard are those cases to handle and prove?
Yeah, anything that's a repetitive motion, the classic case is the cashier doing one of these type of maneuvers with the scanner. Those type of things, you're generally going to need a doctor to back you up and say, yeah, these symptoms, it's caused this repetitive trauma injury, and give an expert opinion to a reasonable degree of medical certainty, those legal, magical legal words that workers' comp requires. And that's just another reason to get an attorney, because a lot of times the doctors aren't putting those magic words in the reports. You go to a hearing, you don't have those magic words, and then your case gets derailed or you get denied benefits.
And strategically, because of that, instead of trying to prove that case, which is much harder, sometimes an attorney can help and say, look, you had repetitive issues, but you had this one issue during that time period which put you in a position where now you can't work or you can't do certain things. So even though there was repetitive trauma as you went along, we could look at one event and which is easier to prove. So it does help to get an attorney in that
Well, if
case.
you're out of work and you're on workers' compensation, but then your doctor says, okay, I approve you for light duty, but your work doesn't have any light duty for you to do.
Yeah, I think the important thing is make yourself available and say, well, yeah, I'm back. I'll do light duty, and then have them say no, because if what you don't want to be in a position where they offer light duty and you refused it, right, Rick?
Right.
And then
Yeah, the insurance company, they don't want to be paying you while you're out of work, so they're always pushing you back to work. And then the employer feels obligated to just make up a position. Even they don't realize they can just say, hey, we don't have any light duty, insurance company, fulfill your duties under the insurance. But you get this push and pull, and it's a conflict, and the injured employee is caught in the middle of it, and it just causes problems.
That's about all the time that we have for Legal Access here today. We appreciate you watching. And if you have any further questions about workers' compensation, you can email us. Email address is legalaccess@wmbfnews.com. And next week when we get together, we're going to be talking about family law, divorce, separations, adoptions, things like that. I want to thank Ian McGuire, Mike Smith, and also Rick O'Neill for being here. I'm Dave Priest. We'll see you next week for the next edition of Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the